Hi, everyone, and welcome to another episode of Talking Law. Today, we're actually going to be talking about sunset dates. What is a sunset date in an off-the-plan contract? There are many misconceptions and misunderstandings out there in the market. So this episode is all about dispelling some of the myths around sunset dates in Queensland. How do sunset dates work under the legislation? And from a practical point of view, for you as the consumer, as the buyer, how do the sunset dates affect you under an off-the-plan contract? So let's get into it. Firstly, what is a sunset date? So to be very clear from the beginning, let's point out a sunset date is not a date that the developer comes up of his own volition or something of his choosing, in that a sunset date in an off-the-plan contract is mandatory to be in an off-the-plan contract because the legislation says so. So in Queensland, we have two pieces of critical legislation. We have the Land Sales Act, which governs subdivisions of land. So chopping up a parcel of land into individual lots for the end consumer to buy that lot and then eventually build their home on it after settlement. So they're buying a block of land. So that is under the Land Sales Act. So the other critical legislation in Queensland is the Body Corporate and Community Management Act, which is a very important piece of legislation that's been around a very long time, since 97, and that governs off-the-plan contracts in strata, in bodies corporate. So that means townhouses, mid-rises, and high-rises. So what's important here is what the legislation says. And the legislation says that when a developer is creating an off-the-plan project and issuing off-the-plan contracts, it is mandatory that each contract must contain a sunset date. And the developer, yes, does get to choose what that sunset date is, but it must contain a sunset date. Otherwise, the contract would not be considered valid under the legislation. So it makes sense, because without a sunset date, the contract could continue indefinitely. And just on that point, under contract law, you always must have an end date to know when the parties have to perform the conditions under that contract, when they have to perform them by, and also what happens if those conditions are not performed by a particular date set in the contract, as to those parties' rights, whether they can walk away, get deposits back, etc. So it's very important to understand that sunset dates are mandatory, they're critical, they must be in off-the-plan contracts, but it is up to the developer to choose what that sunset date is. So let's talk about those two pieces of legislation first, because that's pretty important here to understand how sunset dates work. Firstly, you've got the two pieces of legislation, as I said, the predominant ones, of course, the Land Sales Act. Now, the Land Sales Act already dictates the maximum sunset date that a developer can choose for land subdivisions as 18 months from the contract date. Under the Body Corporate and Community Management Act, that is an act that governs the maximum time frame for a sunset date can be 5.5 years. So just think about that for a moment. If you're in a land subdivision, 99% of the time, the off-the-plan contract is always going to have 18 months as the sunset date. It's pretty rare that it's less than that 18-month period set by statute, by legislation. But over here on the other side, under the Body Corporate and Community Management Act, when you've got a maximum date that the developer can actually choose of up to 5.5 years, that means it is on the developer to choose, is it going to be 2 years, 3 years, 3.5, 4, 4.5, or 5 years, or the maximum 5.5 years. So the timing of a sunset date is very important when you enter into an off-the-plan contract, obviously, because to understand, and we've talked about this on prior episodes, when you sign an off-the-plan contract as a consumer, as a buyer, and you get past the cooling off period, you are locked in eddy, as I call it, locked in eddy. So meaning that you are locked into that off-the-plan contract right up until either one of two things happens. The project is completed, so settlement's called for, and you settle, and you've satisfied your obligations under that contract, and you have settled on your off-the-plan contract before that expiry of the sunset date. Or the other thing that might have happened is that the developer can't complete and he terminates the contract. Now, that's a separate issue, perhaps for another episode, but suffice to say, you are locked in till the end. So it's important for buyers from the beginning to understand what is the maximum or what is the sunset date set in that contract. Now, compare that to the practical side of what the agent might have told the buyers from the beginning about the anticipated project completion date. So this is where often when I talk to buyers, there's a misunderstanding and a misconception. When they come to see me, they say, look, the agent has said this is a 3-year project. It's going to be completed roughly in 3 years or give or take. And I'm happy with that. Now, when I look at the contract, if that contract has a sunset date of 5.5 years, then obviously I am to explain to the buyer, as I do on a daily basis, the agent might have said 3 years, and hopefully that project is completed within 3 years, give or take. And we don't know whether it will be. But the reality, and this is what I explain to buyers, is it may not be that 3 years. And the developer, if he takes a whole 5.5 years, because that's the sunset date in the contract, to actually get that project completed, then you can't do anything about that. So that's why it's important for buyers to understand what is the sunset date. So the sunset date, in essence, is a date that is in your off-the-plan contract that gives the developer the maximum time to actually get that contract completed or that project completed, which actually means registration of that plan that your lawyer hopefully would have shown you from the beginning and given you advice on your lot in that proposed plan, which is not yet registered. So hence the words, when you're looking at what does off the plan mean, you're buying off the plan. So off the proposed plan that the developer organizes and arranges with his surveyor and other consultants from the beginning. Well, this is the proposed project, this is the proposed plan, and it shows all the proposed lots at different levels within the building. So the idea being that at the end of the project, of course, to reach all the targets that a developer has to do, he has to register that plan down the track. And the registration of the plan is what triggers everything else to follow, which is registration of individual titles for all of those lots, all of those apartments, if it's in a high-rise or a mid-rise or a townhouse, registration of titles, and then the calling of settlements for buyers. So on the one hand, you have the sunset date set in the contract, which is very much governed, firstly, by the legislation, but also the second part is it's governed by what the developer anticipates will be completion of the project. And that of itself brings into play a number of issues in this current economic market that we're seeing about what developers anticipate will be the completion of their project. And there are many variables that come into play when they make that decision. Obviously, they want to give themselves the maximum flexibility because the critical part to understand is when you get to that sunset date, under bodies corporate of the plan, then either party can terminate that contract if the project isn't completed by that sunset date. So that's really important to understand. So when we say completed, we're talking about getting that plan registered and seeing titles registering for the individual lots in that building. Okay, so that's what we're talking about when we get to the end. And if that has not been accomplished by the developer by that expiry date of the sunset date, then either party can terminate. Now, sometimes in contracts, there are rights for the developer to extend that date for unforeseen events that may have occurred. For example, council might be being difficult, or they might be imposing conditions that it takes the developer some time to actually overcome and satisfy those conditions for the council to give their big green tick of approval on the plan and seal that plan. Sealing of the plan by council is essential for the plan to be registered or to be lodged for registration with Queensland Titles, I should say. So there are many hurdles for a developer to jump through, many hoops to jump through at the end to get that plan registered, to call for settlement with the buyers. So it's critical to obviously understand that process. Now, as I said, if the project's not completed, completed being registration of the plan has not been achieved, titles have not been issued, and the developer is not seeking to have an extension of that sunset date, presuming it's prior to that maximum 5.5 years already given under statute, then neither party can terminate. And at that point, yes, the buyer gets their deposit back. Obviously, a disappointed buyer at that point, particularly if it's been a very long sunset date period. Now, that is how the current state of play is in Queensland for bodies corporate off the plan. Let's move over to the other side with land subdivisions, because there was a critical change last year in Queensland in November 23. I've talked about it before on the show, but it's very important to understand how land subdivisions for off the plan work now, because when you get to that expiry of the sunset date, and again, we've got to see triggers such as, is the plan registered, have the titles been issued, can settlement occur? Now, if that has not been achieved by that sunset date, and remember, as I said before, the sunset date, or the maximum sunset date you can have in Queensland at the moment for land subdivisions, is 18 months. It's pretty short. So there was once upon a time when 18 months really was enough time for the developer to complete what he had to do for land subdivisions. In this current market, it's questionable whether a developer can actually complete in 18 months, to be honest. It would depend on when they started to sell those lots off the plan as well, and how far into all the civil works that they would have already undertaken perhaps before they started marketing. But that's another issue to talk about perhaps on another day, but important to understand the process practically. So the critical change now since November 23 is twofold. One, when you get to the sunset date, or the expiry of the sunset date, developers can't just terminate anymore, because it might be in the contract, it might say that they can do it, but the legislation was changed with some fundamental, significant changes. So when you get to the end of the sunset date, if those trigger things have not occurred, being the plan hasn't registered, the titles haven't issued, settlement can't occur. Okay, so what happens now? What happens now is that the developer can't just terminate automatically. What he has to do is either get the buyer's consent, and he has to send a sunset date notice to explain what has happened to that point and why he can't actually get the project completed by that expiry of the 18 months. If that's the sunset date, it could be 15 months, whatever it is in the contract, but let's call it 18 months because that's the maximum time in the legislation. Then if he can't get the buyer's consent, then he has to go off and get a Supreme Court order. Now, these are fundamental changes, and they do follow the New South Wales provisions, which were changed quite a few years ago. So we are following New South Wales in relation to land subdivisions and off the plans and sunset dates, which I'm happy to see, because I think that at the end of a project, when buyers have waited so long, if it can't be completed by a particular date, and there could be very good justifiable reasons why a developer can't complete by that date. But in this case, because of the changes, developers now have to justify, have to prove, have to show what are the reasons why the project can't be completed. But remember, we're only talking about land subdivisions. So when they get to that point, they have to either get the buyer's consent. The buyer does not have to give their consent. They do have to reply to a notice issued, but they don't have to give it. So then the seller has to go off to the Supreme Court and get an order, which isn't really that easy. And because there are any new changes to the laws, we haven't actually seen this work yet in practice. We haven't actually seen any matter in court yet play out. But the legislation does issue, or does list, a number of factors that a developer would have to show. Okay, so these are really important. For example, is it just and equitable to grant an order to allow termination of a contract? To do that, the court has to look at various things, which does include the developer's conduct. What has the developer done to date? What have they achieved to date, or what have they not achieved, and why? Is it feasible that the project can't be completed, and why? So at a practical level, you can imagine the developer would have to front up to show why the delays have occurred, what's happened in this 18-month period to cause now the situation where the developer says, I can't settle, I can't complete. There are other variables and factors that the court would have to look at, such as what is the effect of terminating the contract on the seller, on the buyer? What impact does it have on terminating the contract for the buyer? Now, that's pretty critical. Has the developer acted in bad faith? How has each party performed under the contract? So these are really, really interesting factors that a court will have to take into account. So it will not be easy anymore for developers to simply terminate for land subdivisions. Now, the other critical part, the second factor to mention, is that these laws were retrospective, which is unusual. So that means that when these laws came in November 23 for Queensland, if you were already under an off-the-plan contract that had not yet reached its sunset date, you were able to take advantage, both parties, of the changes to the laws, meaning those laws now affected those existing off-the-plan contracts. So retrospectively. So it wasn't a case where the laws only then took effect for new contracts moving forward. It actually impacts all existing off-the-plan contracts from that critical date in November 2023. So that's really, really significant for Queensland. It's not very often, and it's very rare that laws are made retrospectively. And these laws really came about. This is the driving factor for Queensland government and the Department of Justice and the Attorney General that all listened, was protection of the consumers. That's where it was really coming from, because there were many stories that hit the headlines on land subdivisions where the developer just terminated at the 18-month mark and buyers were devastated. And then that developer sold those lands or those lots at a higher price. So not all developers do that, and that's not all developers act in that manner, and that's the sole purpose of why they terminated those contracts. But it was enough for the Department of Justice and the Attorney General to sit up and listen to those stories that did make the headlines in the last 18 months, 2 years in Queensland, to say, look, we need some change. Now, when those changes were made, I say, unfortunately, those changes did not transcend and transfer into bodies corporate off the plan. So currently, the sunset date laws are not changed yet. However, I am very confident, quietly confident, that in the background, the Attorney General is going to make these changes to the sunset date for off the plan for bodies corporate. And when those laws do come in, not if, but when, I think it's only a matter of time, then they will also be retrospective. Fairly confident about that. Otherwise, there'll be an inequity in the market. And I'm fairly confident they will come into effect, because without these changes also impacting buyers in off the plan for bodies corporate, there will really be, in my personal view, an inequity in the market, because you'll have buyer protection, consumer protection over here only for land subdivisions, and you won't have it over here for those buyers that buy in bodies corporate off the plan. And I think it needs to be an equal playing field, if I can say, across the board in Queensland. And indeed, if we were to compare with our counterpart down in New South Wales, when New South Wales made those changes, it also were changes that impacted all off the plan contracts, not cherry picking land subdivisions only without bodies corporate. It impacted all off the plan contracts. And I think it should also be that way here in Queensland. So that is it in a nutshell. Hopefully I've dispelled some myths for buyers about how sunset dates actually work in off-the-plan contracts. Please feel free to reach out to me if you have any queries, comments, or questions in the feed on this YouTube channel. Otherwise, I look forward to giving you some more valuable information on off-the-plan contracts on our next episode of Talking Law. See you then.
Thanks for watching. If you found this content helpful, please like and subscribe to stay updated on property and various other law insights. Dispel brings almost 30 years of expertise to her YouTube channel, sharing knowledge gained from her extensive career, including work with major Gold Coast developers and prestigious projects like Q1 and Palazzo Versarchi. As a member of the Queensland Law Society's Property and Development Law Committee, Dispel offers valuable perspectives on legal matters affecting the property market. Don't miss out on future videos. Hit that notification bell to learn from one of the Gold Coast's most experienced property lawyers.